Okay, class, we're up to Chapter 1, Video 11, How to Read and Understand Case Law. Okay, so when a court decides a case, they write an opinion, which is in a paragraph dialogue type of form, and it's going to have in it a little history of the case, the facts of the case, what the issue is, how the prior cases apply and how any statutes apply, and then they're going to give their answer to the issue in the case and give you what we call a holding, which is a principle of law that the court is applying to the case. Okay, so when the opinion is published, you're going to have different types of opinions. A unanimous opinion is when all the judges on that particular court that are hearing that particular case agree. Okay, a majority opinion is where they don't all agree, but the majority has overruled the minority, so to speak. So in the Supreme Court of the United States, with 9 justices, if you have a 5-4 decision, the 5 is the majority, and somebody is appointed to write the opinion for that majority. A concurring opinion is a person who votes with the majority on the outcome of the case, but disagrees with the reasoning for reaching that outcome, and usually is writing a concurring opinion in order to express why they disagree with that opinion. A dissenting opinion is somebody who does not agree with the majority, and they write a decision explaining why they don't agree with the majority. Dissenting opinions can be important because, dissenting opinions can be important because at some time in the future they may become the majority because the court or the members of the court may change their mind. Also because oftentimes the dissenting opinion will point out the limitations of the majority opinion. In other words, show that it's limited to certain circumstances, certain facts, and that lower courts should not broaden it anymore or interpret it any more broadly than the actual facts of the case and the conclusion, the decision imply. A per curiam opinion is a unanimous opinion that does not indicate which judge wrote it, that's a per curiam. Okay, so when you see the title of a case, it's going to be in the name of the parties. So if it's individuals, it'll be something like Smith versus Jones. Smith indicating, at least in the trial court, the plaintiff, the person bringing the case, Jones being the defendant, the person responding. In some cases, instead of calling the person the plaintiff, we call him the petitioner, and instead of the defendant being the defendant, they would be the respondent. Those would be in civil cases, and normally those would be cases in equity. When a case is appealed, then if, let's say, the defendant lost and the defendant is appealing, sometimes, depending upon the court, the names are going to stay the same, Smith versus Jones. Sometimes, however, the court will put the person appealing first, so it would be Jones versus Smith in that type of court, because you would reverse the names of the parties. So the person appealing a case is called the appellant, and the person against whom the appeal is taken is called the appellee. And remember that it doesn't have to be an individual. It can be a fictitious person like a business, or it could be a government agency or part of the government. Okay, I'm going to stop there with number 11. Remember that the magic word for Chapter 1 is federalism.